meeting of March 15th to order. And before we do a roll call, there's been a request to allow remote participation from Member Garcia under Section 7A of the Open Meetings Act, pursuant to Section A of that act. The quorum of the members of the public body is physically present. A public body may allow that member to attend the meeting by other means for personal illness, appointment, or family or other emergency. I know that Member Garcia had knee surgery, so that is certainly fits in there. Is there a motion to allow Member Garcia to participate under Section 7A? There's a motion and a second. All in favor?
Aye.
Any opposed? Motion carries. Welcome, Member Garcia. And with that, Eileen, would you take the roll?
Sure. Member Krajewski?
Here.
Member Colbert? Here. Member Garcia? Here. Member Ozog? Here. Member Rutledge? Here. Chair Torrentori?
Here. Thank you. Under Chairman's remarks, I would point to ask that I will entertain a motion to amend item 8D. That is an action item requested by Neighbor Place Condominium for 1, building permit issuance, and 2, waiver of zoning entitlement application fees. And entertain a motion to separate those two into item 8D1 for the building permit issuance and 8D2 for waiver of zoning entitlement application fees. Motion or a second?
Second.
Motion second. And all those in favor?
Aye. Aye.
None opposed, and the agenda is amended. I have no other chairman's remarks. We'll move on to public comment. We do have public comment. Just so those who are here to publicly comment, I want you to understand there are 3 minutes per person. They will take place at the beginning of the meeting. Any comment on zoning items is limited to discussion or testimony or evidence presented at the Zoning Board of Appeals. We do not hear any new testimony or evidence at this meeting, and our total allotted time is 30 minutes for all members who wish to comment. We will start with Steve Hammond, is it, from representing Salerno?
Yep. Thank you, board. I would just like the proposed ordinance exception will reduce the culvert and will increase both water volume and water velocity being sent to both my property at 15W407 East Harvard Street and the property across the street, the Weiler property. And with respect to the exception, I had requested for an engineering study to kind of confirm that the water velocity and the total water, kind of displaced by, the proposed, kind of setback be less than or equal to what it is today. I haven't seen that. Thanks.
Okay, thank you. Maria here.
Mr. Chairman, if you don't mind, I will be the lead person and the rest of our group will speak.
And who are you, ma'am?
Kathleen West.
Okay. All right, Kathleen, if you want to go first, then go ahead. You're on here.
Good morning. I am Kathleen West, and our law firm represents Kids World. The Zoning Board of Appeals had 3 concerns which led to its decision. The evidence presented by Kids World during the public hearing addressed and refuted these concerns. Sufficient parking will be provided. Kids World analyzes parking needs based on total enrollment of 131 children with an average daily attendance of 103. Kids World does not operate like a school, which has specific start and end times. Children are dropped off and picked up at various times during a 3-hour period in the morning and a 3-hour period in the afternoon. The maximum number of children dropped off or picked up in one 30-minute period, either in the afternoon or in the morning, is 25. The average length of time for a parent to utilize a parking space for drop-off or pickup is 6 minutes. The site plan provides 33 parking spaces. The zoning regulations require 25. Kids World is providing 8 more spaces than is required. This proposed use will not result in queuing on Chicago Avenue nor parking in the adjacent residential neighborhood. The proposed improvement of this property includes the shifting of the entrance 152 feet to the east and the restriping of the turn lanes on Chicago Avenue. Kids World had a traffic impact study prepared, which concluded that with these improvements, the access driveway and the parking can adequately accommodate the traffic projected to be generated by this facility with no impact on Chicago Avenue nor the neighborhood. This improvement of the property will not negatively impact stormwater. Detention is not required because of the limited size and scope of the work to be done. However, BMPs will be required. The engineering department did not have any concerns and indicated that it would review this in the normal building permit process. At the public hearing, the traffic engineer and the civil engineer for Kids World presented their analyses for parking, traffic flow, and stormwater management. No evidence was presented by the neighbors, which substantiated their claims, nor refuted the testimony of the Kids World engineers. This property has been used for commercial purposes for many, many years. So Kids World requests that the development committee recommended approval of the conditional use and the exceptions and reject the zoning board of appeals recommendation.
Thank you. Maria here.
My name is Maria Herr. I'm a 20-year resident of Lyle and have lived in DuPage County for 46 years. I've worked at child care center since 1987 and have a bachelor's degree in early childhood leadership. I'm committed to early childhood, and my main focus is always how we can make things better for the children, especially now with so much focus on their social and emotional health. I do want to address the parking concerns as well. Dropping off at childcare is not the same as dropping off at the school, just like she said. Our prime pickup and drop off times are 7 to 9 and 3 to 6, but every parent doesn't come at the same time. Parents are not going to park outside of our parking lot and then walk with their infant through school ager to get to our building. In the very slim chance that there's not a spot, we would wait in our large parking lot for a parent to leave and then drop off their child. I worked off Deal Road at a center for 20 years that had 150 children, and not once did a family park on the street or outside of our parking lot. Parents realize it's not safe to do so and walk with their children when they can park in the parking lot. Children's Creative Corner has been part of the Lyle community since 1994 in the current building. We are currently in a strip mall, which does present some challenges for us. So to have this new space would just be amazing. There are so many improvements that we can make, like a sensory garden as part of our playground. It'll be more beneficial for the children if we can build this rather than not have the area in our existing building. It is a wonderful opportunity to connect the children with nature. The possibilities are endless for us having these. Thank you.
Thank you. Tony, I can't read the last. Zoltek. Zoltek.
Yes, okay. Dear Mon David, I'll try to not repeat some of the items that were brought before me, but my name is Tony. My family owned Children's Creative Corner Child Care Center. I would like to tell you a little bit about our family owned business. I'm a long-term resident of DuPage County for over 22 years. My wife lived in Naperville all her life until we moved to Bloomingdale 10 years ago. We have many teachers in our family. My wife, my mother, my aunt, my mother-in-law, they're all teachers. And my wife worked at a preschool teacher that was a preschool teacher in a corporate-owned child care center. She felt like children and teachers were just positive and negative dollar signs to corporate. And that's why she wanted to do better for both of them. This is how we came to operate Children's Creative Corner since 2011. And because we strive to do better for our children and families, we're looking at this new facility with more green space, more natural light in the classroom. This new facility will be similarly sized with our existing one and almost the same capacity. Even though the property can accommodate a larger building, we would like to maintain much of the existing green space, trees, for children to have quality outdoor time. Currently, we are only half a mile east on Chicago Avenue, and our traffic is already flowing on the same main road. After 11 years, we know very well the needs of our families, how much parking we need, their arrival and departure, how much staff we needed each time, etc. As I mentioned, we're a small family-owned business, and we would not invest in this project if we thought that there's a chance our customer needs are not being met. It's not a good business decision. They would just go somewhere else to another child care center. Parents, as I mentioned before, they will not park across the street or walk 500 feet with their 2-year-old. Child care centers serve the communities in the neighborhoods, and some of them are located within the neighborhood. Ours, in this case, would be a standalone facility on the same main road that we are now only half a mile away. These final site plans, traffic reports, and other supported documents were presented to different DuPage County departments, and they had no objections for any of them. Input from DUDA, fire, and other departments was taken under consideration from our engineers, who have worked with the county on many other projects as well. Children's Creative Corner has been serving Lyle and Naperville community since 1994. We'll already serve a few families from Century Hill subdivision that it will be next to the new facility. They have expressed excitement about us moving closer, and they said other families with young children in the subdivision are supportive of this project as well. A letter from one of the parents is included in your documents. We will continue to do our best for our families and staff because we consider them extended family. You can help us do even better by approving this project and allow us to offer a lot more for our children and the families we serve. Thank you.
Thank you. And lastly, to Deva. Can't read the list. Okay.
Good morning. My name is Diva Mayauskas. I'm the president of Napier Place Condominium Association. We're here today to ask for an exception to issue balcony railing replacement permits. Back in 2015, we received an ordinance violation from the village of Lisle for all our balconies, which are now currently over 50 years old. They are in horrible shape. The village of Lisle sued us, and that case was dismissed by Judge Wheaton, not because the balconies were good, but because this is a limited common element and each owner is responsible for their own repair. As an association, we could not do it for them. Most owners, there were 170 balconies, most owners did them. And then we de-annexed from Lisle into DuPage. Well, we were always in DuPage County, we de-annexed. And we had about 30 to 40 balconies that were not done. Homeowners requested permits from the county. They were reviewed, they were okay, but they were denied because as of the de-annexation, we are now automatically zoned R1 and we are a multifamily complex. My request is to allow for the homeowners who submit their permit applications to be granted the permit and issued the permit, because these balconies, I have photos if anybody wants, are in terrible shape. If my concern, and I'm usually a pretty easygoing president, my concern is if some child or some adult falls off that 4th floor and breaks their neck, then all hell is going to break loose. We need to get those balconies fixed. So we're kind of in a little bit of a conundrum. That's my request one. I don't know if you want me to also address the variance, the application for zoning. We have filed an application for zoning from R1 to multifamily. That was all given in, I believe, last week. We're asking for a waiver in that we are a very low middle income complex. We are definitely the UN of Lisle. We have waitresses, we have taxi drivers, all of which have been very, very impacted by COVID and have been out of work. We also have investors. I have investors coming in saying, I am owed $40,000. I am owed $30,000 because of, as you know, the moratorium on evictions that was up for about a year and a half. We paid $84,000 to the village of Lisle to de-annex. We paid $300,000 for the privilege of paying $84,000 in attorney fees and costs. Judge Cox from the federal court ordered that we de-annex. She called it a divorce. It was a horrible situation. We're also now, each homeowner is facing about $5,000 to repair that.
I'm gonna ask you to wrap up if you would, please.
So that's my second request, that the waiver for fees. And I'm not really sure exactly what the amount was. I looked at, so I think we can discuss that later. Thank you.
Thank you. Okay, that concludes the public comment portion of the meeting. Thank you all. We'll move on to approval of the minutes. I'll entertain a motion to approve the minutes of February 15th. So moved.
Second.
Motion to second. Any additions, corrections, or deletions? Hearing none, seeing none. All those in favor?
Aye.
Any opposed? And the minutes are approved. Moving on to budget transfers, I'll entertain a motion to approve the budget transfer in the amount of $21,900 to cover benefit payments. So a motion and a second. Any questions, comments? Hearing none, seeing none. All those in favor?
Aye.
Any opposed? And the transfer is approved. We have nothing under informational. Moving on to regulatory services. I'll entertain a motion to approve 2022-33 for recommendation for approval of the contract to Harris Government for for annual software maintenance and support services. There's a motion. Is there a second?
Second.
Motion and a second. Any questions, comments? My understanding from Public Works is that we are phasing this out, hopefully at some point, but it's necessary now. No questions, no comments. All those in favor?
Aye.
Opposed, and the motion carries. We'll entertain a motion to approve DCO 20-22 ordinance zoning 22-00010 Z21-104. Zoning hearing officer's recommendation to approve a variation to reduce the corner side setback for a new house from 30 feet to approximately 8 feet. There's a motion and a second. Any questions, comments?
About that concern that was raised here.
That's-
Getting a report.
Paul, do you want to address that?
So this petitioner has worked with the county stormwater department and also the township highway commissioner, who has jurisdiction over the unimproved right of way to the east of the property. They've come up with a stormwater and drainage plan that they believe will deal with the existing conditions on the property. To the question today, when the development does come in for permits, they'll have to show the stormwater department that they will not be increasing any runoff beyond what is currently coming from the property. That's a requirement for all new construction. So that'll be part of the permitting process.
Does that answer your question, Mark?
Yes.
Okay. Any other questions, comments? Okay, hearing none. All those in favor? Opposed? And the ordinance is approved. I will entertain a motion to approve DCO 19-22 ordinance zoning 22-0000003 Z21-105. Kids World, a zoning board of appeals recommendation to deny a conditional use for a planned development, exception to reduce the west side setback from parking from 20 to approximately 5 feet, an exception to reduce the front yard setback for parking from 30 to approximately 5 feet, and an exception to reduce the front yard setback for a new company sign from 15 feet to approximately 10 feet. There was a motion and a second. Questions, comments? Member Petruski, we'll start with you.
Yeah, just looking at the evidence in here, and I see that the zoning board denied it based on, it's like D, E, and F. They said did not meet the proposed, E and F all relate to stormwater.
Yes.
They said they demonstrated they haven't increased in potential flood damage. Didn't our stormwater sign off on it?
Stormwater has not signed off on it. When we have a zoning case, we send information to the jurisdictions that would ultimately review this as part of the building permit process. Stormwater has indicated they have no concerns, but any issues that they would have would be addressed at permitting phase.
Sure.
The big issue was whether or not they were going to be required to have detention. We worked with our stormwater department, determined that they do not require detention, so there's no need for a detention facility on site. They will have to provide a best management practice, which essentially is a rain garden or vegetated swale on site, which they have proposed and they will follow as part of the permitting process.
So if they, I mean, they were to have like the similar last issue, last case, if they're gonna have a stormwater or a flooding issue, permits wouldn't be issued, they wouldn't be able to go forward with it anyway.
That's correct.
So to me, that's a moot point. So the left here is the D, which is unduly increasing traffic congestion, has not been demonstrated. But, we had somebody talk about today, but there's the traffic report in there that doesn't seem to indicate there's going to be increase in traffic. You see a member nodding her head on the report there too. So she must have read that same traffic report.
did.
So, but I don't see the increased traffic, and hence I'm not sure how this even was denied. It seems like it fits everything.
Well, we've had a couple of public hearings on this, and the petitioner has addressed the traffic concerns, not only with a traffic report, but also with the Division of Transportation. And similar to what Stormwater said and indicated in their comments to the ZBA and this board, they don't have any concerns. They did require that the entrance be moved from the west side of the property, where it currently is, to the east side of the property. And the final details of engineering will be taken up at time of permitting. But in terms of any fatal flaws, Division of Transportation has indicated there aren't any anymore.
Okay, yeah, and I mean, I look at the end of it, and then the write up at the end seemed to be the dissenting opinion. That seemed to be spot on. So, all right, thank you.
Next was,
Thank you. Well,
Yeah, that was a question I had because I wasn't at the ZBA meeting, so I don't, do we have somebody today from traffic that could explain the report? Or, I mean, flooding is also another concern because there was a massive flood in that area years ago. And, so that's one of the other concerns. And then also the traffic report. Is there anybody here today from?
We don't have anybody here from transportation. I don't know.
It's conclusions,
Well,
right?
I know.
The traffic engineer is not here today. But the traffic report did indicate some changes that they required the petitioner to make in order to accommodate the Division of Transportation's concerns, and those things have been made on the plan.
Okay, the ZBA voted to deny. What was their main basis of the meeting?
It
Because I
was,
wasn't there.
it was a concern about traffic and a concern about stormwater. Now, relative to traffic, their concern was that people coming to this facility would use an entrance point to the subdivision further to the east to do a U-turn to come back westbound to get into this facility. This facility is on the north side of the property. So there's a concern that people who would be traveling from the west to try and do a left-hand turn or make a left-hand turn to get into the property. If they couldn't make that turn, they would come down to the neighborhood to the east, do a U-turn in that area, and then come back down to the property. The petitioners, the traffic report has indicated that they're going to reduce some striping on the roadway on Chicago Avenue to accommodate that concern. So there'd be a more of a queue lane for people to make a left-hand turn into the facility and therefore wouldn't back up traffic on Chicago. More importantly, there wouldn't be the need to have to come into the subdivision practically to turn around and come back westbound to get in.
Okay, that just is a little concerning with children in the car, with the U-turn and just safety issues. Okay, thank you.
Member Rosa again. We'll go to Member Garcia afterwards.
Thank you, Mr. Chairman. I just want to clarify, I am in support of this project. I thought that the traffic report answered everything that you need answered. I suppose you could put a no U-turn allowed sign if that was necessary in order to, but I think that would happen very rarely because of the 3-hour drop-off period that you have described. It was described in the traffic report. And I thought the traffic report was really clear. So I'm not really quite sure what the zoning board was thinking. So I'm going to be voting in favor of the project. And I just want to be sure that I vote the correct way. I'm going to be voting no.
Aye. The motion is in the affirmative, so
The
if
motion
you,
is in the affirmative. I just want to clarify that.
yes,
So I
always
will
in the
be voting
affirmative,
in favor of the development.
then your
of
vote
this.
would be aye.
My vote will be aye today because I thought that the traffic report was really clear and I think that there's not going to be any particular impact on the neighbors. You can't stop somebody unless you want to put a U-turn sign up, which would then make it a ticketable offense. But otherwise, I think the fact that it's really a long drop-off period is not going to be a big issue. And generally, people are certainly not there to stay for half an hour. They want to move along with their day. So I think it'll be a benefit. Thank you.
Paul, one second. Is this area where the potential no U-turn sign has been suggested a dedicated street, or is that a private property?
It's a dedicated right of way, but it's in the city. I take that back. No, it is a dedicated right of way that is Division of Transportation in there.
So
there can be a no
who would be the party responsible for putting that sign up?
Division of Transportation.
That'd be us.
Correct.
Could that become a part of this petition?
Yes.
Okay. Member Garcia.
Thanks, Chairman. Yeah, I appreciate all the help you gave me, Paul, with this week when I had a lot of questions on this. And I am going to be voting in favor of this also. I think they've done all of their homework and they've done a great job with the traffic study and showing that, that is not an issue anymore. All the traffic's coming out onto Chicago or Maple Avenue. So that's going to be wonderful. And I have found with every project I have followed that if they have a BMP, much like the last one we just voted for, so the best management practices, that the stormwater gets much less and it becomes less of a problem. So I think that this will be working out perfect with this going forward. So thank you so much.
Any other questions from any of the members? Okay, I did notice there's an objection from the Century Hills Homeowners Association on here. Can you enlighten us on their objections?
Once again, their main concern was the traffic and people using their entranceway on Concord into their subdivision to make a U-turn to come back westbound to get into this facility. As we mentioned before in the traffic report, based on several items that the traffic report suggested be put into play, those things will be put into play that will ameliorate that concern. One thing I would mention is that I mentioned that if we put a no U-turn at the intersection, it's possible that DUDOT would be the jurisdiction. It's also possible that the Township Highway Commissioner would be the jurisdiction, but in both instances, it would either be the county or the Commissioner for Loudoun Township. It's not a city roadway. So either way, I don't think there would be a problem with either one of those jurisdictions putting the U-turn, no U-turn sign up.
And in either way, if it was made a condition, that would be the condition that would have to appear regardless of what the jurisdictional entity would be to put that down.
Correct. If, for instance, those jurisdictions have a problem with that, we'd have to bring that back to the committee
Back to the committee.
and have you review that.
Any other questions? Yes?
One question, well, what am I missing? I don't understand why somebody would choose to make a U-turn when they could merely make a left turn.
Don't disagree, but that was a concern that was raised by the objectors and the homeowners association. So the traffic study addressed that, and they addressed it in such a way that there are items that can and will need to be put in place that the petitioner is willing to do. Not only things put in place on the road right of way, like additional striping, but also education to the clientele that's going to be using the facility. Don't make that U-turn. Don't go to that further eastern access way to make the U-turn.
Yeah, okay.
But
I
it's
think
just-
it's a
it is a
solution
concern.
looking for a problem. I'll be voting in support of this project too.
Member Rozak.
It would seem to me that you would be the jerk parent who would be driving past your fellow parents to make this U-turn and then have to come backwards and look at everybody in the left-hand lane. I don't really want to be that person, just saying. So, yeah, it does really.
We don't have any jerk parents. Okay.
No, I'm sure we
No,
don't,
no.
but it really does seem like a problem. It is.
Other questions? Okay. Is there an appetite for the maker of this motion to add the condition of a no U-turn sign on the property? Who made the motion?
Member Ozark.
Rosa?
Yes, I can, we can
Okay, so
stipulate that we would like to have a no U-turn at the northwest corner,
that is-
northeast
okay.
corner
Be the intersection of Concord and Chicago.
in Chicago. And that it would be prohibited through either the township or the county. And we would have that added, and we will deal with whichever jurisdiction is actually in charge.
Okay,
Fair enough.
okay with the seconder?
Second.
Okay, so we have a motion and a second as amended regarding DCO 19-22. Have a roll call vote, please.
Member Ozark,
Yes.
member Rutledge,
This is merely on the motion, correct?
Yes, these two separate votes.
This is just the motion. This is on the.
The U-turn
amendment.
sign
This is on the
motion.
amendment.
Thank you, yes.
Clarification, sorry. So we're,
This is a vote on the motion to amend the ordinance, including now the no U-turn sign. And then once we get to that, then we'll go on the entire.
the underlying.
That's correct.
member Krajewski,
Aye.
member Covert. Aye. Member Garcia,
Aye.
Chair Tornatori.
Aye. Okay, so now we have the ordinance as amended. I'll entertain a motion to approve the motion as amended.
So moved.
Second.
A motion and a second. Any questions, comments, concerns?
Third.
Roll call, please.
Member Rutledge,
Aye.
member Ozog,
Yes.
member Krajewski,
Aye.
member Covert,
No,
member Garcia,
Aye.
Chair Tornatori.
No. And the motion carries. The ordinance is approved. Oh, this isn't going to be a, it's not a variation. Okay, got it. Okay, moving on to action item D. Request by Neighbor Place Condominium Association, as we indicated, we've amended the agenda. This is for a building permit issuance. Paul, can you or Jim bring us a little bit up to speed I know that you talked to me about it, but members of the committee regarding this building permit issuance.
Yeah, from the building, for the first piece of the, as it was amended for the permits, I can address that, and I think Paul can speak more towards the zoning application process when we get to the second half. So at this point, we have Napier Place has de-annexed, as the president of the HOA had indicated. And they have had multiple tenants come in and apply for permits to make repairs to the railings on their units. Part of our permitting process is to have the various branches of the county sign off on it. Building reviews it, zoning reviews it, drainage if it applies, health department if it applies. We have to have all those approvals in order to issue it. So right now what we've got is we cannot issue it because we can't get the zoning approved because they don't have the correct zoning for their development. When they de-annexed, they became an R1 in the unincorporated area. They're a multifamily unit. So it's kind of a catch-22. We're being advised there are issues with the railings. Our ordinance doesn't allow us to issue a permit till they have their zoning entitlements sorted out. So we've come to you today to ask the committee for permission to issue the railing permits as they've been applied for without the zoning entitlement, so we can make any changes or repairs that need to be made. Again, we've been informed by the association there are issues, so we're trying to see if we can resolve that piece, and then they'll have to complete the zoning entitlement process, and then once that's taken care of, anything in the future will be issued. In their letter, they asked for permission to just do the railings. I prepared a memorandum to send to the board. In it, I actually indicated railings, decking, and the deck structures. In case when we get in there, we find that there's something more than a railing. I didn't want to have to come back to you and say, oh, by the way, can we now replace the deck framing? So we don't anticipate, we've not inspected these railings. We don't anticipate there to be any more than just the railing issues. This was determined by Lyle before they came to us. So that's kind of where we're at today. We're just looking for your approval to allow us to issue the permits so they can make those repairs. These are not repairs that are being taken on by the HOA. They are being taken on by the individual homeowners. So we have some homeowners who've worked their way through the process and are kind of stuck.
So just so I understand it, and again, I think for all of our purposes, this request is to have the building permit issuance waived because of the issue of the R1 for the entire association, not individual unit owners coming individually asking for these permits, correct? The way it's in front of us right now.
The request has come to us from the homeowners association representing all of the individual homeowners.
So the homeowners association, by the words of her president, each unit owner is responsible for their own railings, et cetera, correct?
Correct.
Okay. So what's before us is a blanket agreement to waive the permit process, as opposed to what might be another way to go about it, an individual waiver, as the individual owners would come before us and apply for those permits. That would be another way. So, Member Hobart.
I have a really quick question. So I mean, I think these railings need to be built. They need it, obviously. I guess my question is, if they don't have the R1 designation yet, but we're doing the waiver of zoning entitlement application. So I'm thinking if each.
No, we're not doing that yet. Let's stay
Okay.
on the building
Okay.
permit issue.
I'm just trying to, I guess my question would be for residents that want, that would get these railings replaced, and in the future they get a different zoning designation, would they have to change their railing structure again and it would cost them more money, or would there be additional fees, or would those fees come? Okay.
No, once the railings are repaired, if they need to be repaired, they'll be fine. It won't affect future zoning designations.
Okay. I guess I'm connecting with the fees. I just want to know if the fees would have to be.
Forget about the fees right now. Let's focus
Okay.
on And just so we understand, any of the waivers of the permits are being based on a life safety issuance. Oh, right?
If I could clarify, we're not waiving the permits.
I'm not waiving the permits, I'm
We're
sorry.
waiving the zoning authorization for the permitting process.
To allow them to
So we
do
can
it,
issue
but
building
it's based on life safety, which we really don't know exists until we go out there and inspect them.
Right.
So again, to give a blanket waiver, if you will, is.
So we're voting to allow the individual unit to get a permit to do this repair.
No, that's not what we're voting on right now.
We're
What is
allowing-
being asked of, Paul, you want, or Jim, tell us specifically, Jim, what's being asked for, and then we can vote that up or down.
The homeowners association has asked for is for us to, for the county, the committee to allow the building department to issue permits to the individual owners to make the repairs to the railings. I guess on behalf of the owners, the association has come in and made the request. We did not get individual requests from each owner that needs to have the work done.
So the homeowners association will be looking for a permit to go ahead.
No, the individual owners will still be
Okay.
required to get.
But
their
we're
own
giving
permits.
permission to get the permit in spite of the zoning issue.
Right, I think we were looking at it more of a holistic, the homeowners association is applying for the zoning relief. The homeowners association is kind of asking us to work with their homeowners and issue building permits to the individual owners.
Okay, but they
rather
need
than
this
bringing-
permission first before they can go
Rather than
forward.
bringing individual homeowners in, they
And
came in on their behalf.
do they have to fit the criteria that's been set up by the homeowners association for what's actually going to be installed? Is
Well,
there,
We don't enforce homeowners association regulations, they would be required to meet the building code.
building code?
So if there was a specific design criteria or something that the homeowners association is looking for, we would not enforce that in this jurisdiction or any other. We just strictly what
Right,
the
that
building
would be
code
dealing with
requires.
the homeowners, but we would make sure that it fits the building code and does the job that it's
Correct.
supposed to do. Okay, fine.
But this is in essence a workaround
Of
from
the zoning.
individual owners coming in to
Got it.
make applications for individual permits.
Yeah.
Remember, producing.
What, is our rules different than Lyle? Is that why they left?
I'm not sure why they left Lyle. I know there was multiple lawsuits that were involved. Ultimately, I believe they ended up in federal court.
This one is our code more, I guess.
I don't know.
Allows a lot more than.
It shouldn't. We're following the same building code. We're following the 2021 IBC for these. So it would be the same international building codes anybody else is using. So I'm not sure what but I don't know the origin of the issue in Lyle.
Other issues not on our agenda.
Correct.
Anyone have any questions? Yes.
Well, thank you.
Chaplain.
Thank you. Chair
Grace does what she
Tornatore.
does.
Yes, I don't serve on the committee, but I want to come today. So, what, you mentioned that there were two possible options for this committee to take on this. There's one, like, we could do individual, could we do individual?
Well, as I understand it, and the request, correct me if I'm wrong, Jim, is to essentially give a blanket building permit
Correct.
allowance for any and all of the railings to be repaired without individual owners coming to the county to get individual inspections and individual permits.
It would be without the individual owners having to come before the committee and asking for this permission. This would be the homeowners association saying, we think we've got 30 to 40 of these that may need repair. And we'd ask you to allow the building department to issue those 30 or 40 without you having to hear 30 or 40 requests from homeowners
And
associations.
that's something we don't do
Right.
otherwise.
Yeah.
Because they're out of compliance with
With the zoning.
Zoning, and they are working towards getting their zoning. I mean, that will be an important part of this, is that they complete the zoning process, because otherwise, the next time we have a permit request, we're not gonna grant it, we can't, so.
And also, we would also say balcony and components.
Correct.
Yes.
Yeah, this would be just strictly for work on the balconies. It's not gonna be us.
Can we add components in case?
Well, I think I did add in the
Oh, I'm sorry.
memorandum that it was the balcony, the decking, and the structure underneath,
Yeah.
so the framing structures.
Member Garcia, I think I saw your hand up.
Yes, thank you, Chairman. Yeah, I just was kind of like saying exactly what Jim just said. Because to me, and I have a lot of experience with Lyle condos, now neighbor condos, because I did work for the Village of Lyle for, 20 years. So I kind of know what the whole history is, so we'll talk about that later. But I think what this is going to do, because they already have some permits that have actually been brought in and are waiting to be issued. And so this is going to allow the work to begin. And so basically what this means, what I'm hearing and what I think that we're going to do by approving this is to allow them to actually do the safety, things that they need to do on these railings and if the decks. My question also is, have they maybe had an inspector out there at all yet to look at any of them, or are we waiting for this vote?
The answer to that is no, we've not. We have not had any interaction with the decks, so we would want this approval to be for us, the decks, the railings that we determine need to be repaired. They're telling us they think it's 30 to 40, so we would at some point want to get out there and take a look at those, but we have not gone out and done assessments on any of the railings on the property. It's at this point just been the homeowners who have been coming to us asking for permits.
Okay, so this would just allow the process to continue if we were to approve this then, and while we're waiting for the zoning designation to change, right?
Correct. Yes, that's correct.
And Jim, how different, assuming that we allow a blanket issuance of these permits with our inspectors going out to inspect and authorizing however many that person deems necessary. How different is that process versus what would be the quote unquote normal process for a condominium association or homeowners association to do this?
In the normal process, somebody would come in and make an application.
An individual unit owner.
Typically, when we see railings and things like this done in other locations, it's generally done by the homeowners association. They'll come in and for example, if they're going to do a re-roof, they'll re-roof the
But let me
entire
stop you.
building.
Wouldn't that be only if the homeowners association was responsible for the railings?
It could very well be, yeah. I'm not an expert in condominium law. But generally, we don't see them come in individually for these types of things because we're looking, I think as the homeowners association, they're usually looking for some continuity in design and installation. In this case, they are telling us that it is the responsibility under some limited design elements that the homeowners are responsible to make the repairs. I believe that they have designs that they're following so that they look like the rest of the company on the railings. We don't enforce that. That's entirely up to them. Like I said, they just have to meet the building code requirement for spacing, structural integrity, that type of stuff.
Okay. Yes.
If I recall, my mother-in-law lived in a condo for 10 years, and my gut feeling is that this is an unusual situation. Usually the balconies would be considered a common, similar to a roof. And so this makes this a little bit different in terms of what you're dealing with.
My experience.
I'm afraid, I don't think we can recognize you, so.
I can clarify if you want.
No, ma'am. I'm
No,
sorry. We
sorry.
don't take any evidence.
But I think that's where this is, again, another, besides all the other unusual situations, I think that's an unusual element that would be individual versus a common property issue.
Well,
So-
just for the record, I used to be president of a 561 unit condominium association, and it was our individual unit owners who were responsible for the.
Was it? Okay, so I think that.
So I mean, I think it all depends on the bylaws, yeah. Okay, you're leaving. Okay, we still have a quorum. Okay. So how about we do this? I'll entertain a motion to approve building permit issuance through this application made by the homeowners association, but only upon inspection by our building department for railings, decks, and what was the other thing you can add, Jim? I'm sorry.
I think I put railings, decks, and framing.
Framing, okay. Yeah, where it's deemed to be a life safety issue, I'm sorry, as determined by our inspector, because that's the waiver.
And that's a motion.
I'd like somebody to make that motion other than me. Member
So moved.
Ozak made that motion,
So
okay.
moved.
There's a
I
motion.
second.
Second from member Garcia. Any questions, comments? All those in favor?
Aye.
Aye.
Any opposed? Then the motion carries. Moving on to amended item 8D2. This is the waiver of the zoning entitlement application fee. So we understand that the people have de-annexed from Lyle. Paul, you want to come in and tell us why we're looking at this?
Sure. We talked about a little bit by matter of law, when there's de-annexation by state statute, the property automatically goes to the most restrictive zoning category of the jurisdiction. In our jurisdiction, that's R1 single family. As we've heard, this is a multifamily development. And as a result, they'd have to seek zoning relief to bring the property into a zoning district and in compliance with the county zoning regulations. And we can't issue any building permits until that is done, other than what you just heard today. We've spoken with the lawyers for the homeowners association before the de-annexation and also the court, and made them aware of this. They've indicated to us over the period of time that they've been de-annexed that they would like to apply, but that the cost is problematic. So they're asking for a waiver from the fee. The fee in this case, to the minimum fee in this case, to apply for zoning relief, which would be zoning relief from R1 to a multifamily district, R6, 7, or 8. I'm sorry, R5, 6, or 7, and also a planned development. The fee for that is approximately $20,000. There's a base fee, and then there's also a per unit fee, and there's approximately 273 units in here. The unit fee is $50. So when you add all that up, it comes to approximately $20,000. We've received the application, so we'll be processing the application to start the public hearing before the Zoning Board of Appeals. But we will not move forward with the public hearing until the resolution of the fees occurs.
So the application has been made, but the homeowners association is asking to have the fees waived.
That's correct.
Okay. Any questions, comments on that? Anybody from the committee? Yes.
So I'm inclined not to waive these fees. I think $20,000 is a reasonable fee for all of this. And I think, what's the HOA, about $300? Was it $298, $300 a month?
It's a little over 300 for a 2-bedroom.
So you're paying 300, these people are paying 300 in association fees. So that comes out to like, what's, I don't know, 300 times 273 is what, a year? I mean, you're collecting a substantial amount in association fees, especially for lower, taxi drivers and waitresses and things like that, that live in this area. So I just don't see that there's the hardship to pay this $20,000 with that association fee that you're collecting.
Any other questions from any board members? Member Garcia, I thought you were just saying hello to me, Paul, with that.
Was hi. Yeah, no, I'm going to agree with the member Chaplin on that. I don't, I would like to see some kind of payment plan. I know that they have a lot of expenses that they have before them, and I'm totally empathetic to that. But I do believe they need to pay these fees also. So, I mean, I would love to see some kind of payment plan put forward and have a deposit down before we go through the paperwork, and then have a payment plan that they have to stick to after that. So that's what I would be in favor of, but I would not be in favor of waiving.
Okay. Any other comments? Okay, well, my 2 cents for what it's worth is I would be against any waiver of any fees. De-annexation was the choice of the homeowners association. If they don't pay for it, the taxpayers of the county pay for it. My quick simple math, if you got 273 units and it's a total of 300,000 or $30,000, it's $100 a unit essentially, to be done in a special assessment or otherwise. I wouldn't be even in favor of a payment plan. I pay it like anybody else. And quite frankly, maybe we should have done this the opposite way of what we did, because if we would have had the zoning application fees ahead of time, we would have been bothering with the other. But we want to get those railings fixed if in fact there's a safety issue. So that's why we did it the way we did it. But anyhow, I'd be voting no on that. So I will entertain a motion to approve a waiver of the zoning entitlement application fees as set forth in our agenda.
Second.
This is a motion and a second. If you're against it, you vote no. If you're for the waiver, you vote yes.
Member Ozog,
No.
Member Rutledge,
No.
Member Krajewski,
No.
Member Garcia,
No.
Chair Tornatori.
No. And the motion fails. Under staff reports, fiscal year 22 strategic initiative implementation summary update.
So I'll be real quick. I know we're kind of going long today. So the strategic initiatives we have for this year are really very similar to what we had last year. The initiative number one is just using technology, kind of as a recap. January 31st, we went live with the new software. And it is really going to take the better part of the year to completely change our entire business operation. And that's really what we're focusing on right now. We have gone from a paper system to a paperless system, and it has been very challenging for the residents. It's been very challenging for staff. The software it's functioned fairly well. It's had some issues. You can test like crazy, but until you actually use it, you don't know all of the intricacies of how it's all going to work. So we're working very closely with Acela. We did, with the board's approval, sign on to the managed services agreement at the end of last year, which has been a huge asset for us. It has given us an entirely new layer of people to work with on their end, a whole nother team. They're working very closely with our IT staff. We have 2 new IT employees in the department, and they're being cost shared across stormwater, public works, DOT, and building. So that's worked out very well. Second item on the item is the periodic code updates. We just updated the building code at the end of last year. We went live with the 2021 codes January 1st. This really is us continually reviewing the new codes and practicality, how they work, because it's a whole new code for us. Additionally, we've done some training this spring, with the Suburban Building Officials Conference, and have identified some information, I think, regarding decks in particular, that we'd like to actually probably come back later in the year. We'll spend some time checking for any Scrivener's errors or anything like that we may have lost in going through the whole code process, and kind of try and bring a little more comprehensive amendments back to you guys later in the year. But we'd like to add some additional information into our residential code, kind of tightening up decks. We haven't had any failures with decks, and we don't want any. So it's a big area where a lot of people, all of a sudden you've got the whole prom picture out on the deck and it comes away from the wall. It's not because the deck itself failed, it's because the connections and things like that to the house can become an issue over time. There are a lot of, for example, the materials that are being used today. There's so many chemicals and the preservatives. You can't use a standard nail any longer. It rots it right away, it just dissolves it. So you're using double and triple dipped galvanized nails or stainless steel and things like that. So there's a lot of fasteners that really we need to take a very close look at. Our code addresses those, but we think that there's more we can do with it. And then the third initiative is what Paul and Tesca brought to you, the Lake Street corridor study across multiple jurisdictions at the west end of Lake Street. Tesca gave us a presentation a couple meetings ago on that whole IGA through CMAP. So Paul will be working very closely with those guys. I think you guys, Paul, will be doing a lot more in the community meetings this year and pushing that forward.
Okay, thank you. I've been alerted we might have a potential quorum problem because we lost a couple of members, so I'll entertain a motion to allow Member Chaplin to be a member of the committee. Second, all those in favor?
Aye.
Aye.
Okay, any old business? Any new business? Objection or adjourned? Thank you.
Thank you. Thanks.